All right, welcome back. We are continuing our day with alternative enforcement regimes, who can sue and on whose behalf. And you will see that this is a subject which we provided you a video of, and so you had some other speakers who could present on this. I would encourage you to send us some your comments about the reading assignments and videos and which of those worked better for you and which worked better for the preparation. We're delighted to have Judge Anna Manasco with us to lead us in this panel. Judge Manasco is on the U.S. District Court for the Northern District of Alabama. She received her Bachelor of Arts from Emory University, her Master of Science in DPhil from the University of Oxford, and her JD from Yale Law School. She served as a law clerk to Judge William Pryor in the U.S. Court of Appeals for the 11th Circuit, and before that, between those things, was in private practice. So I'm going to turn it over to Judge Manasco to lead us through on alternative enforcement regimes.
Great, thank you so much. Can everybody hear me all right? All right, good morning. It is our pleasure to be here. This is a very exciting panel to get to moderate. For the most part, I am going to turn it over to the panelists and then get out of the way and do my only job, which is to keep time and direct traffic for Q&A. But I'll let them introduce themselves. We have a great mix of private practice and academic scholarship on the panel, and so I know we'll have a very interesting variety of perspectives. So we've asked everybody to speak for 11 or 12 minutes so that we have ample time for questions on this really interesting topic. So I'll turn it over to Shelley first.
Thank you, Judge.
Great.
Good morning, everyone. So my name is Shelley Slade. I'm with the law firm of Vogel, Slade, and Goldstein. For 33 years, I have been enforcing the Federal False Claims Act. For the first 10 years as an attorney at the Department of Justice, and for the last 23 years on the private side, exclusively representing qui tam plaintiffs who bring cases under the Federal False Claims Act. So what is qui tam? Qui tam is an ancient legal concept that permits private individuals to sue in the name of their government to enforce federal law. The False Claims Act allows private individuals to sue to redress fraud on the federal government. They're incentivized to do that by a award provision of between 15 and 30% of the government's recovery. They bring their cases, under seal. The government can intervene and take them over, but if the government decides that they are okay with the relator going forward, then the relator can go forward into litigation on their own with their own counsel. The federal law has many state analogs. I think well over half the states have their own false claims law, so this will be applicable to the state judges in the audience as well, because most of the state laws are very closely modeled on the wording of the Federal False Claims Act. The qui tam provisions, as I mentioned, give an award of 15 to 30%, but also attorney's fees to a successful qui tam plaintiff, and they're also called relators, or whistleblowers more colloquially. And I'll start out with a disclosure that, having done this work for 33 years, both within the government enforcing the law and outside, I am a huge fan of the qui tam provisions. In fact, when I first interviewed for my job at the Civil Fraud Section at the Department of Justice back in 1990, I read the statute, and I thought it was the most brilliant statute I had read ever. I went into the interviews with that attitude, expressed those views. Unbeknownst to me, not everybody in the Civil Fraud Section at the time was a huge fan of the qui tam provisions. And this was 1990. So again, 1989, some of you may know, was the year that William Barr, who was then with the Office of Legal Counsel, had authored a memo declaring the qui tam provisions to be unconstitutional. And in fact, he even quoted the famous English jurist Lord Coke, who had described informants bringing qui tam cases as venomous vermin. Let that sink in. He was a public official at the time. However, both President Bush's Attorney General, Thornburgh, and Solicitor General disagreed with Mr. Barr and decided that the Department of Justice would not bring cases or bring briefs arguing the unconstitutionality of the qui tam provisions. So I get the job anyway. About a year later, the Supreme Court, 2001 actually, the Supreme Court addressed the Article 3 standing question and determined that qui tam relators are assignees of the government's claim and do have Article 3 standing. And that was a decision authored by Justice Scalia. It was unanimous as to that part of the decision. They did not address, however, the Article 2 issues, which concern whether the qui tam provisions might violate the Appointments Clause or the Take Care Clause. So fast forwarding 33 years, having done this work for 33 years, I'm still a huge fan of the provisions, and I'm going to talk a little bit about how the False Claims Act works, the evidence that the key TAM provisions are extremely effective at returning stolen funds to the Treasury, which may not relate to constitutionality, but certainly does inject an important policy point, and then I'll turn to the constitutionality questions that are raised under Article 2. So the False Claims Act was enacted in 1863 during the Civil War. It was a response to evidence of rampant fraud on the Union Army. The Union Army was buying horses that ended up being lame, buying gunpowder, it thought, that ended up being sacks of sawdust, muskets that didn't work, et cetera. And a muckraking congressman named Congressman Van Wyck convened the first ever select committee on government contracts and had many hearings into the corruption and fraud in government procurement. He eventually turned to looking at the Customs House in New York, which was also full of corruption, and at that point, his colleagues booted him from his position, but he went on to have a very distinguished career with the Union Army. He was an avid abolitionist. So he said something at the time that erroneously has been attributed many times to President Lincoln, but the historical record proves otherwise. It was Congressman Van Wyck who said, "Worse than traitors in arms are the men pretending loyalty to the flag, who feast and fatten on the misfortunes of the nation, while patriot blood is crimsoning the plains of the South, and the bodies of their countrymen are moldering in dust." So the False Claims Act in its current iteration, I don't have enough time to go through all the different iterations since 1863, but in its current iteration, it imposes liability on those who knowingly submit false claims for government funds, and also on related infractions, such as making false statements knowingly to get false claims paid. The law does not require intent to defraud. The scienter element is knowingly, and that is defined to include both deliberate ignorance of the truth or falsity of claims and reckless disregard of the truth or falsity of claims. So in other words, it goes after the proverbial corporation with its head in the sand that doesn't want to know what the law is, that doesn't want to know what the regs are, and proceeds with a path with a good sense that their claims may not be legal. A violation of the law recurs regardless of whether the government pays a false claim. Although a damage award, of course, may be imposed, only the false claims cause financial damage to the United States. The financial consequences of violating the False Claims Act are severe. Triple damage remedy, as I may have mentioned. The statutory penalties for each violation are between $13,000 and $27,000 per violation. So if you have a Medicare or Medicaid fraud case, for example, in theory, the statutory penalties could be huge if you have a lot of smaller claims. In addition, government agency debarment and suspension authorities can suspend or debar a contractor for a violation of the False Claims Act, various sorts of fraud and false statements, and HHS, Office of Inspector General, similarly can exclude from Medicare and Medicaid companies that have violated the law. So turning now more specifically to the main focus of the panel, which is the key TAM provisions. Key TAM, for those not familiar with the concept, is short for the Latin phrase, and I'm not a Latin scholar, so please excuse my pronunciation, but qui tam pro domino rege, quam pro se ipso in hoc parte sequitur, meaning he who sues in this matter for the king as well as for himself. And including these qui tam provisions in the original 1863 statute, and by the way, at that point, the qui tam relator could get 50% of the government's recovery, which was then a double damage recovery, whereas now it's 15 to 30%. Congress was utilizing a model that had been around since the founding of our country. The first Congress, the second, the third, the fourth, had passed laws of qui tam provisions. In addition, those provisions, in turn, were founded on ancient qui tam law of England. Since the Middle Ages, England had laws on the books that permitted private citizens to supplement the resources of the crown, which were very limited, to enforce penal law. One of the sponsors of the original False Claims Act, Senator Jacob Howard, this is going back to the 1860s, explained that he had included a qui tam provision with an award for the private citizen in light of, quote, the old-fashioned idea of holding out a temptation and setting a rogue to catch a rogue, which is the safest and most expeditious way I've ever discovered of bringing rogues to justice. So his assumption was that these would be individuals significantly involved in the fraud in practice. I think most qui tam practitioners would tell you our clients at worst are foot soldiers in the fraud. So most attorneys handling qui tam cases, such as myself, take cases on contingency, which means we have very little interest in bringing a weak case. We get paid only if the government recovers and only if our client is then eligible for a reward. My firm takes on perhaps one case for every 100 contacts made to our firm, and about one case out of every 7 or 8 that we vet, in some depth. Okay, so there's little doubt, even among detractors of qui tam, that the provisions have been enormously successful in terms of returning stolen funds to the Treasury. Between 1987 and 2022, actions filed by whistleblowers, this is not False Claims Act actions filed by the government, but the ones filed initially by whistleblowers, have brought back $50 billion to the Treasury. In contrast, during that period of time, 87 to 22, actions developed and filed by the United States on its own have brought back less than 50% of that amount, $20 billion. So the power of the qui tam provisions is also demonstrated by what happened to the law between 1943 and 1986. During that period of time, there was an amendment to the statute that's not in the law anymore, but that prevented a qui tam relator from bringing a case if related information was somewhere in the government's possession in some obscure file. During that period of time, from 1943 to 1987, recoveries under the law were anemic, and the law fell into virtual disuse, because what individual would want to risk the retaliation in their job, in their career, the stigmatization, if some obscure entry in a government file could bar their case? So in '86, the year before Congress finally got rid of that provision, recoveries under the law were just $50 million. And if you fast forward 11 years later, after Congress beefed up the law, strengthened the qui tam provisions, both protections for relators and incentives, the recoveries in 1 year went from $1 billion. So over 11 years, from 50 million to 1 billion, with 60% of the amount attributable to qui tam actions. Now, part of the reason was not just the qui tam provisions becoming stronger and that bar being eliminated, but also Congress gave DOJ some very powerful investigative tools. So why is it the case that the qui tam provisions, that whistleblowers make such a difference financially in these cases? And this is, again, looking at policy now, not constitutionality. But first of all, it's detection. An individual, a private informant who's working inside a company or working closely with a company is simply in a much better position to detect a fraud scam, which of course is concealed by its very nature. Second big reason is resources. While the Department of Justice and its client agencies have some pretty good investigative tools, search warrants if there's a criminal overlapping case, investigative subpoenas for even testimony in these False Claims Act cases, they are short on manpower and they are short on funding. When the qui tam plaintiff brings his case, they bring to the table the resources of their private counsel. So they bring to the table, first of all, the ability to assemble a larger legal team, co-counseling if the case goes into litigation if necessary, and the cash to hire experts and other consultants. As was stated in the Senate report accompanying the 1986 amendments, when large profitable corporations are the subject of a fraud investigation, they are, quote, able to devote many times the manpower and resources available to the government. In far too many instances, the government's enforcement team is overmatched by the legal teams major contractors retain. So some critics of the law, usually defense counsel, complain that qui tam plaintiffs are usually disgruntled former employees, motivated by revenge and greed. I will tell you that is completely the opposite of my experience. I mean, yes, we get a few calls from crazies. Yes, we occasionally get calls from people who are trying to get revenge. But by and far, the overwhelming majority of people who call us are well-motivated, are independent thinkers, which is why they detect the scam, and are motivated by conscience. And there was a study about 11 years ago in the New England Journal of Medicine of 47 pharmaceutical whistleblowers that concluded as follows. Generally, a whistleblower's first move was to try to address problems internally. They became litigators either accidentally while pursuing other claims or as a last resort. The most prevalent motivations reported were personal values and self-preservation rather than financial incentives. So now I'm going to sort of accelerate my discussion of the constitutionality because I'm about out of time. But on the article, two questions, that being the take care clause and the appointments clause, Supreme Court has not yet addressed the issue. 6 courts of appeals have, and in the situations before them, every one of those courts of appeals has found the qui tam provision to be constitutional under the take care clause and the appointments clause. Some of the courts have relied on the Supreme Court's standard in Morrison v. Olson, in which the special counsel statute was upheld as constitutional under Article 2. And that particular statute at the time involved Congress appointing the special counsel, whereas here the DOJ has an opportunity to remove the qui tam or to take over the case. And so I do want to quickly go through the many ways in which Congress, in enacting the qui tam provisions, put in controls to make sure the executive branch retains sufficient control over the case. First, the case has to be filed under seal for 60 days with extensions for good cause shown, so the government can use covert means to investigate if they wish and can evaluate the case. At the end of that seal period, the government can take over the case. If they don't take over the case, they can do 2 things. They can move to dismiss it over the objections of the relator. Under Rule 41A is what applies according to the recent Supreme Court decision on the issue, or they can decline and let the government, let the relator, the qui tam plaintiff, go forward on their own. Down the road, if they have trouble with how the relator is handling the case, or they think that the evidence in the law no longer supports the cause of action, they can intervene for good cause, a very low bar, and then move again to dismiss over the objections of the relator. They can settle the case over the objections of the relator as long as they show the court that the settlement is fair, adequate, and reasonable. They can move the court to restrict the relator's participation in the case if it's an intervened case, or discovery actions in a declined case. Finally, qui tam plaintiffs may not file cases if the government has already filed a similar case. And my final point, I guess, is that in addition to those 6 courts of appeals I mentioned, 2 others have opined in dicta on the constitutionality under Article 2 of these qui tam provisions. And those 2 have indicated very strongly that they would be inclined to agree with the first 6 courts that have addressed the issue. So I'm sorry I've gone over, but
Thank
with
you.
that, I'll turn it over to
Thank you, that's
Mr.
great.
Mitchell.
Mr. Mitchell?
Thank you, and may it please the courts. The thesis of my remarks today is that private civil enforcement mechanisms, such as qui tam relator actions, private attorney general statutes, and laws such as the Texas Heartbeat Act that empower any random person to sue lawbreakers, are not only constitutional, they are an essential feature of our system of checks and balances. They empower legislatures, both state and federal, to counteract lawless behavior by the executive and the judicial branches. They also have the power to erode the widely held belief in the doctrine of judicial supremacy and to create incentives for the Supreme Court to be more rule-like and clear in its constitutional doctrines. All of these are positive and salutary features of private civil enforcement regimes that people from across the political and jurisprudential spectrum should embrace. I especially want to push back against the criticism that has been leveled at private civil enforcement regimes from conservative-leaning jurists and commentators who have long expressed skepticism of the constitutionality and the normative desirability of qui tam, private attorneys general, and other types of private civil enforcement regimes. These criticisms appear most prominently in the writings of Justice Scalia, both in his academic writings, which the slide is, well, if the slide actually presented all of what I had, it would show you the law review article he wrote in the early 1980s in the Suffolk Law Review, where he penned a piece that was entitled "The Doctrine of Standing as an Essential Element of the Separation of Powers." And also Justice Scalia wrote the Supreme Court's opinion in Lujan against Defenders of Wildlife, which many, though not all, state judiciaries, to my sorrow, have incorporated into their state constitutional standing doctrines. But I'm going to offer a more sanguine view of private civil enforcement. So let's go through the benefits, and actually Shelley touched on many of these, so I can talk about these very quickly. There are 4 benefits that I have on the screen. Some of these are actually quite obvious. One reason you would want to have private civil enforcement is because you do not trust the executive to faithfully enforce the law. Democratic legislators may be concerned that a Republican administration won't enforce environmental laws or consumer protection laws. Republican legislators, by contrast, might fear that a Democratic administration might not fully enforce abortion restrictions or other types of criminal laws. At the state level, same concerns arise. I think there's also the added wrinkle of Soros-backed DAs in some local jurisdictions in certain states who may not be willing to fully enforce the criminal laws of the states. So that might be one reason a legislature might opt for private civil enforcement, either as a supplement to or a substitute for a conventional public enforcement regime. The second is actually, I think, the most provocative, which is private civil enforcement can be used to check the power of the Supreme Court of the United States and the judiciary as a whole. That's a dangerous thing to say in a room full of judges. But one example I'll get into that will show specifically how private civil enforcement can be used as part of their checks and balances on the courts, and that is the Texas Heartbeat Act. I'll just mention that briefly up front, and we'll go into that in a little more detail later. Third and fourth benefits, I think Shelley already touched on these. Some unlawful acts are very hard for the prosecutors or public officials to detect, especially things like fraud and conspiracy. Some of these types of laws that are broken or crimes that are committed can be done in a very subtle and underhanded way. And then a fourth benefit is that key TAM-related actions can encourage people to blow the whistle on a conspiracy. Some things like Medicaid fraud require many different people to cooperate. And if you have key TAM or private civil enforcement, it creates a very strong financial incentive for one of those people to defect, essentially turn state's evidence, and cash in if they are able to expose the fraud that they either perceive or perhaps they even actively participated in, but have recanted and changed their ways. So let's give some look to one example of private civil enforcement, again, as a check and balance device that was used in the case of Senate Bill 8, also known as the Texas Heartbeat Act. This was actually used to check the powers of the judiciary. And many people remain nonplussed at the fact, I think everyone in the room has heard about the Texas Heartbeat Act, and it took effect about 2 years ago. People are still, I think, rather surprised that a state was able to successfully outlaw conduct that the Supreme Court of the United States at the time had held to be constitutionally protected under its opinions in Roe against Wade and Planned Parenthood against Casey. So how on earth was Texas able to devise a law that was able to survive court challenge at a time when Roe had not yet been overruled? And the answer to this question requires a proper understanding of the judicial power and a recognition that the public's views and many lawyers' views of the judicial role have been tainted by the sloppy and inaccurate nomenclature that is all too often used to describe judicial review and the behavior of courts. And I have on the slide right now an expression that I hope none of you will ever say or use either in your judicial writing or in conversation or in any particular context. This idea, this pernicious idea that courts somehow strike down statutes, and the scare quotes on the slide are intentional. Actually, I don't even want to repeat this phrase. We're going to bleep this out the way we redact profanity, all right? There is no such thing, all right? Courts do not and cannot do that thing to statutes. Even if a court declares a statute unconstitutional, the statute continues to exist. It has not been vetoed or canceled or revoked or suspended or put on hold or blocked in any way by a court decision, because courts do not have the power to act on statutes. All that a judicial pronouncement of unconstitutionality means is that the court won't apply that statute in that particular case or controversy. Or it may mean that the court has enjoined a named defendant from enforcing that law, but the statute is not struck down or stricken from the law books, even if it's been declared unconstitutional by a state or federal court. Courts simply do not wield a veto power or a pre-clearance power over legislation. Unfortunately, we all too often talk about the courts as though they do hold such a power, and that's why this expression is so poisonous and dangerous, because it is conveying and reinforcing an unconstitutional understanding of the judicial power. The powers of the courts are limited to deciding cases or controversies between litigants. They do not have the ability to act directly on a statute. And the belief that courts can somehow cancel or erase a law when they declare it unconstitutional is what I call the writ of erasure fallacy. It's the belief, the mistaken belief, that courts actually hold a power to formally act on the statute by revoking or suspending or striking it down or blocking it or invalidating it or declaring it void or any of these other types of writ of erasure phrases that have crept into the public discourse and even have crept into the judicial discourse. Let me move on to another related issue of terminology, people say all the time that litigants challenge a statute when they sue to enjoin its enforcement. That's also a misnomer. There is no such thing as challenging a statute, either in state court or federal court, because once again, courts cannot act directly upon statutes. Courts can act only against the defendants who have been sued. They can tell a defendant not to enforce a law, but they can't block or suspend the statute itself. The law remains in effect even if a court has told a state official or a federal official not to enforce it. Now, it may often feel as though the court is canceling or suspending the statute when it issues an injunction against its enforcement, because after all, what good is the continued existence of a law if government officials aren't allowed to enforce it? Well, as it turns out, there still can be work for a statute to do, even if its enforcement has been enjoined by a court. We'll develop this point a little bit more when we get into the details of the Texas Heartbeat Act. But again, for now, the point is simply that courts cannot and do not act directly on legislation. They can't revoke statutes or block them from taking effect, and litigants do not challenge statutes when they sue state officials charged with enforcing it. Now, what does all this mean for the Texas Heartbeat Act? The Texas Heartbeat Act was drafted in a way to ban post-heartbeat abortions in Texas at a time when Roe against Wade was still in the books, and to ensure that people in Texas would comply with the law despite the continued existence of Roe against Wade. And it was also drafted to ensure that the statute would survive a court challenge if anyone tried to sue over it. Now, at first, this sounds crazy, but as it happens, it can be done. And how can it be done? By using private civil enforcement as the means of ensuring compliance. There are 4 features of the Texas Heartbeat Act. You probably know about these already. I'll just mention them briefly. First, no state officials are allowed to enforce it. There's a provision in the law that specifically bans state officials from doing anything to enforce or threaten to enforce the law. And that was done on purpose, so there's no state official who can be sued in a pre-enforcement lawsuit. Second, instead of enforcement by state officials, the statute authorizes private individuals to sue anyone who performs or aids or abets an illegal abortion. Civil suits, not criminal prosecution. Successful plaintiffs get at least $10,000 per illegal abortion plus costs and attorney's fees. It's similar to the key tam relator actions that Shelley described earlier, but it's slightly different because in key tam, the relator sues in the name of the state. In this situation, we keep the state completely out of the enforcement side, so the private citizens are suing only in their own capacity, not as representatives or as purported representatives of the state of Texas. Third, we allow lawsuits to be brought in the plaintiff's home county rather than the defendant's county, and then that's because so many of the abortion providers are located in the blue oases within the state of Texas where the elected judges are Democrats who would not enforce the statute if a lawsuit were brought in their courtroom. And then fourth, there's a 4-year statute of limitations, and the statute specifically says that Roe against Wade cannot be relied upon as a defense if it later gets overruled by the Supreme Court, even if Roe was on the books at the time that the post-heartbeat abortion occurred. So the threat of these private civil enforcement lawsuits and the threat that one might lose those private civil enforcement lawsuits if the Supreme Court later overturned Roe was able to induce compliance with the Texas Heartbeat Act despite its incompatibility with the Supreme Court's then existing interpretation of the U.S. Constitution. So this served essentially as a check and balance on the Supreme Court of the United States. That may sound heretical to some people, many perhaps to people in this room, if you believe in judicial supremacy. Judicial supremacy is the idea that when the Supreme Court speaks, when the Supreme Court tells us what the Constitution means in one of its written opinions, that pronouncement from the justices is tantamount and equivalent to the Constitution itself. And to subvert the efficacy of a Supreme Court pronouncement on the meaning of the U.S. Constitution is nothing short of waging war against the Constitution itself. It's treason to the Constitution. That's the idea of judicial supremacy. The Supreme Court articulated this idea in Cooper against Aaron. And if you believe in judicial supremacy, you have no choice but to be appalled at everything that I've been saying for the last 10 minutes, because it's based on the idea that a state...
Poll.
Poll? No, wait. It's based on the idea that a state legislature can adopt a different interpretation of the Constitution from the U.S. Supreme Court's interpretation, and then enact legislation that boxes out the federal judiciary from enforcing the U.S. Supreme Court's contrary view. And you saw this outrage expressed in the opinions of Justice Sotomayor and, to a lesser extent, the opinions of Chief Justice Roberts when these issues were litigated. Justice Sotomayor's attitude was essentially, how dare you enact a statute like this? When we speak, when we say what the Constitution means, your job as a state is to obey. It's not to counteract our pronouncements with your own interpretation of the Constitution and create this device through private civil enforcement that prevents us, the federal judges, from enforcing what we think the Constitution should mean. Now again, if you believe in judicial supremacy, you have no choice but to accept Justice Sotomayor's critique. But judicial supremacy is not in the Constitution. The Constitution does not say anywhere that the Supreme Court of the United States gets to decide what the Constitution means and then impose their beliefs on the rest of us. All the Constitution gives the Supreme Court the power to do is to decide cases or controversies between named litigants. In the course of resolving the case or controversy, the court may opine on what the Constitution means for the purpose of resolving that dispute between those litigants. But the opinion that it writes is nothing more than an essay explaining why that judgment was entered in that particular case between those discrete litigants. It's not an oracle of the Constitution's meaning that everyone else is bound to agree with if they think the Constitution means something else. So one of the features of private civil enforcement that I think has been underappreciated until very recently with the Texas Heartbeat Act is how it can serve as a device to check not only the powers of executive branch officials who are unwilling to enforce the laws that the legislature enact, but also to check the judiciary when the judiciary refuses to enforce state legislation based on what legislators believe to be a mistaken interpretation of the U.S. Constitution. Am I out of time?
You are 30 seconds left.
30 seconds left. There's a lot more to say on the slides. I was going to mention just quickly in my 30 seconds remaining, why does this work? After the Heartbeat Act took effect, there was a lot of hand-wringing from people who said this was the end of constitutional rights as we know them, because people suggested that a state legislature could use this tactic to undermine any Supreme Court decision that they disagree with. That's not quite right. That's actually very hyperbolic, because this tactic will only work in certain limited situations. If the Supreme Court of the United States clearly backs the constitutional right at issue, and if the constitutional right is clearly defined in the Supreme Court's case law, it's very unlikely that the threat of a private civil lawsuit will deter the rights holder from exercising those rights because they have nothing to fear from a private lawsuit. For example, let's suppose a state tried to extend this tactic to someone who criticizes the government. That is so obviously unconstitutional that there's no reason to fear a private civil enforcement suit because a judge will throw that out 5 minutes after it's filed. And there's no reason to think that a plaintiff lawyer who doesn't want to just waste his time and money would bring a civil enforcement lawsuit of this sort. The tactic will only work if the Supreme Court has been unclear about either the scope of the relevant right or their current commitment to the right. And that's why the abortion right in Roe was so vulnerable to this particular tactic. I think I've used up my 30 seconds, so I will stop there, and we can discuss this more in the Q&A.
Thank you. We'll pass it on to Divonne.
Great, thanks for that. And I think I will yield some of my time back for discussion because I hope it will be robust. My name is Divonne Smoyer. I'm a practitioner predominantly in the area of state attorneys general. I'm going to disclose up front, I've defended corporations for 30 years, and the last 20 years before state AGs, although I try to, there's a government affairs component to my practice, which is trying to anticipate problems before they arise or resolve them before they become, before they hit y'all's radars. I want to offer, I'm also an adjunct professor here at Mason. It is the first time I'm on the dais in this particular room, and ironically, the last time I was in here was, I guess, about a week ago, 2 weeks ago. Nancy Pelosi was on the dais here, and prior to that, Cornel West was on the dais here. So when I am in the dais at the law school, which is across the hall, I'm teaching a much smaller seminar to law school students on what state attorney general powers, duties, and authorities. So why are state attorneys general, which seems like a narrow topic, relevant here? Well, they have a lot of powers, duties, and authorities with respect to law enforcement, and also discretion with respect to that, which sort of gets into Jonathan's point about, who should have discretion to enforce these things. And by the way, he was a Solicitor General of Texas, so we do speak a common language in many, many respects. I thought that talking about state AGs, given those enforcement authorities, would be a good lens to examine not only qui tam and private rights of action, but also state-to-state enforcement, contingency counsel enforcement. I'm not going to get into too much detail, but there was, the prior panel talked about third-party litigation funding, which in my view is an alternative enforcement mechanism as well. Quick primer on state AGs, who are they? Every state or commonwealth, in the case of Virginia, Kentucky, and Massachusetts has one. Pennsylvania, right? I'm even from Pennsylvania. Please forgive my omission there. Territories and the District of Columbia. They are generally elected. 43 are elected. The other ones tend to be appointed by the governor. One is elected by the Supreme Court, state Supreme Court in Tennessee. One of my favorite state AGs right now is Jonathan Skrmetti, who was nominated and appointed by the Tennessee Supreme Court. And in Maine, they're elected by the legislature. They have a wide variety of not only enforcement discretions and powers and duties, but they also advise the legislature. They defend the states in many claims. And then, of course, their main bread and butter is enforcing state consumer protection laws and other laws to protect their citizens. They're political. I mean, if 43 are elected, they are political. I just came from late last night, a Republican Attorney General conference where they were talking about their objectives. Tomorrow I fly out to Boston to go to a conference of Democratic state AGs. So I sort of see, I don't speak for AGs, I speak more for myself and then from the defense perspective, although I can articulate what state AGs would say in many cases with respect to alternative enforcement regimes. So in jotting down on the plane last night, gee, what is it that AGs do and how do they overlap with this enforcement regime? I counted seven loose areas. So AGs work with federal co-enforcers to enforce federal laws in many cases. The big sexy one is the Dodd-Frank law that created the CFPB. So state AGs can work with CFPB to enforce financial services laws. They work in tandem with the feds, DOJ and FTC in particular. FTC is probably the most well-known because Section 5 UDAP law under federal law is predominantly the model for state and mini FTC acts with respect to consumer protection. They have, obviously, enforcement authority in their own right under state law. Shelley mentioned state key TAM laws, although your discussion, and I welcome your input on the state laws. In addition to the federal laws, there are state laws, and increasingly there are reverse key TAM laws in the states with respect to failure to pay taxes and things like that. And of course, just like in the federal regime, the states can either intervene and participate or not participate, and the private relator continues, or they can try to kick it out, although I've only seen one case where a state AG has gone in and kicked it out, and that was in Florida. State AGs have to, and I'm going to say deal with, and that sort of shows my hand on what my perspective is, private rights of action. In a number of state consumer protection laws and other laws, there are private rights of action provisions, and increasingly in state data privacy laws that are sometimes married up with state consumer protection laws, there are private rights of action. And then, of course, states have to deal with contingency fee counsel, constantly shopping their cases to state AGs. And those, in the last 25 years, have been moderated to some extent by state laws, private attorney Sunshine Act laws, or transparency and private attorney contracting laws that don't eliminate the plaintiff's lawyer's ability to get contracts with the state. That actually has been litigated. And unlike with respect to the key TAM regime, it has been found pretty much universally to be constitutional for a state to outsource some of its authority, provided that the state AGs retain a degree of control over the litigation. Although, to my knowledge, and I think I would know, there has never been litigation to figure out what degree of control a state AG must have over his or her outside counsel to satisfy the due process requirements with respect to retention of outside counsel. And just as a matter of where the rubber meets the road, if you want to see, I think the best example of how these laws have impacted the state's use of outside counsel is the Mississippi Attorney General's website. This Mississippi state law requires the Attorney General not only to put her contracts, and the current AG is Lynn Fitch. These laws went into effect in advance of her arrival as state AG, but it requires her to put her contracts on the website and also requires her to put disbursement to outside counsel on her website. So it's actually a pretty good way to monitor how these laws can impact what the state AGs do and also what's going on in state AG world with respect to outside counsel. Another category of external enforcement that I don't think has been raised at this conference so far is locality, municipality, state subdivisions, even schools and water districts in the case of water pollution, enforcing state laws to the extent that they have enforcement authority. And we saw that a lot in opioids, and I'm going to get to opioids a little bit later. That's a challenge for state AGs because they get a lot of pressure if Cook County, Illinois is suing, Corporation X for opioids or data privacy. That puts an enormous amount of pressure on the Illinois Attorney General to take a look as well, and to take a look at those cases as well. And oftentimes, those localities are represented by private plaintiffs' lawyers that do not have the same state contracting, disclosure, et cetera, restrictions like Lynn Fitch does in Mississippi. I would get, if I'm speaking for Kwame Raoul, which I'm not, or Lynn Fitch of Mississippi, which I'm not, it undermines their authority and can have the effect of warping their enforcement discretion. And it also gets into their politics as well. There is a mention by Jonathan of DAs not doing their jobs. But some might say if you were now Governor Shapiro of Pennsylvania, who was previously the Attorney General of Pennsylvania before he was elected, he might say that the DAs of Philadelphia and Pittsburgh were overly doing their jobs because he was taking a lot of heat from them and not demanding more money in the opioid settlement. So, and then, of course, as I mentioned, and as we discussed previously, third-party litigation funding, who is actually in control of those things. I've done some work in the past with the Chamber of Commerce on this. The third-party litigation funders can get involved with localities, the plaintiffs' lawyers pitching the states themselves, and the subdivisions. So it's really all over the place in terms of who is pulling the strings on these things and who is the real party of interest. So my larger question I wanted to pose to you all and also to my panelists is, are these things good as a matter of policy? And I've disclosed to you that I've been on the defense side for 30 years and I've been on the AG defense side for 20 years, so I would say no. But the factors that I would consider, and I would ask you all to consider, is enforcement discretion a good thing? And if it is a good thing, with these elected state attorneys general or other elected officials, are these alternative enforcement mechanisms undermining that discretion? Another factor I would consider is, are these enforcement mechanisms hindering or enhancing the orderly, predictable, sensible evolution of jurisprudence, which I imagine you all as judges would be concerned with, but my clients would be certainly as well, because most corporations like a steady, predictable marketplace. For public officials in particular, a keen factor, and I've talked to a lot of AG's offices about that, and their staffs too, and you in particular may have a perspective on this, Are these alternative enforcement regimes and different parties assisting or harming the development of the government office and enforcers in terms of, are we investing in facilitating the growth of great public officials, great public servants? And I would just throw out, I have a name here, but I'm going to just scratch it out. There was, no, don't. There was a chief deputy in the state of Washington after the tobacco litigation, which was, $26 billion, who got an award and said, thanks, so-and-so, our outside plaintiff's lawyers got $100 million, but I got a plaque. Okay, and maybe this resounds with you as judges because you're public servants of the first order. And I would say one of the areas as a practitioner I'm seeing that this is very hot is the area of data privacy. So as you all know, data privacy, AI is fast-moving area, widely evolving, and to be an enforcer in that area is very exciting. And the opportunity to go to a state AG office where the states really is where the action is, not so much on the federal level. And if anyone is in here from the FTC, I apologize, but I think you're going to agree with me. If you're coming out of law school and want to really get great experience in data privacy and go to enforcer, you're going to get, I don't know, your salary is going to be what your salary is, tens of thousands of dollars. But when I go to these conferences, the Republican conferences, the Democratic conferences, I routinely see plaintiffs' firms that don't have much more experience in data privacy than someone coming fresh out of law school, having gone to MIT or another technical college, Georgia Tech, Carnegie Mellon, et cetera, that stand to have enormous windfalls. So I'd submit to you that asymmetry is a matter of policy concern. And then, frankly, from my perspective, again, the corporate perspective is with all of these different parties jockeying around with different incentives, how are these cases to be resolved in an orderly fashion in any measure of a timely, in a timely manner? Or are they just going to go on for decades? So-and-so one-ups over here, and so-and-so one-ups over here, and a most favored nation here, and it just goes on forever. How are businesses going to actually effectively function? The last thing I'll leave you with is, and I'm not sure if there's any press in here. Sometimes I like the press, sometimes I don't, but I think you could be really helpful here, as well as academics and judges, is I would suggest to you that someone undertake, and it's going to be a gargantuan effort, to take a look at what happened with respect to the opioids resolution, the opioids litigation, the opioids resolution that is continuing to evolve. My understanding, I have some inside knowledge, but I don't think anyone knows everything. My understanding, though, is that it was rife with conflicts of interest, localities being represented by one firm in one state that would represent a state itself over here with radically different interests. No one was bold enough to call a conflict on it because, your bread is buttered on one side and you don't want to have the negative fallout on that. But there was so much money involved in that. And, I'm a pro-settlement person, but so many of these negotiations were shrouded in secrecy that I don't think we're ever going to be able to tell what the utility of some of these alternative enforcement mechanisms and regimes are until we take a close look. And that seems like the biggest, lowest hanging fruit to take a look at. So I'm going
Great.
to pass it to you.
Thank you.
Oh,
All
great.
right, we'll pass it to you.
Thanks, Judge. My name's Adam White. I practiced law here in Washington for about a dozen years, and then several years ago moved over to the think tank and academic worlds. I'm a senior fellow at AEI, and I co-direct the program here at Scalia Law titled the Center for the Study of the Administrative State. I guess you could say I worked in practice, now I work in theory. And in addition to all of that, I'm now on the board of two organizations that are very relevant to the topic today. One is a 501c3 titled the Center for Constitutional Responsibility. And the C4 is Citizens for Legal Reform. And especially the C3 is focused on studying these issues of alternative enforcement schemes, private rights of action, and really raising a number of the constitutional questions that I'm going to sketch out today. And I do want to say thanks to the Law and Economics Center for inviting us here today. Much of my work here at the law school involves putting on conferences, and I much prefer speaking at conferences that I myself did not organize. So this is pretty great. You know, my basic bottom line on this point on this panel today is on the question of alternative enforcement schemes. They're certainly on the rise in their prevalence. I also think the constitutional questions surrounding them are also on the rise. And I think it's increasingly likely, maybe this is just me being hopeful, but I think it's increasingly likely that the Supreme Court and perhaps state Supreme Courts will strike down a number of private rights of action, including perhaps the qui tam provisions of the False Claims Act.
Wait, is it qui tam or qui tam?
I'm going to say it both ways throughout, just to.
Okay.
I heard the word struck down. I'm more concerned about that.
Yeah, that was not exactly.
Was that your bad word up here?
Don't-
Listen, I think that when it comes to enforcing public laws, private rights of action raise profound constitutional questions. I'm not talking about strictly private rights like contractual lawsuits and so on. And I'm not even talking so much about private plaintiffs who are genuinely and specifically injured asserting their public rights under, say, the environmental laws. But I'm really talking here about the sorts of things we would describe as private attorneys general lawsuits, and to the extent it doesn't, that term doesn't cover this, the qui tam statutes. Shelley mentioned at the outset that in 1989, William Barr, then head of the Office of Legal Counsel at the Justice Department, drafted a memorandum raising constitutional doubts about the False Claims Act. And I really encourage you to read it. I think we linked it in the show notes, so to speak. We linked it in the materials. This memo, it is dazzling. It's Bill Barr at his best. He doesn't really, he cuts to the chase. He says at the outset of the memo, this question about the constitutionality of the qui tam provisions of the False Claims Act may well be the most important separation of powers question that you will have to address as Attorney General. That's amazing, saying that in 1989. The most important separation of powers question before the Attorney General was going to be the constitutionality of this kind of private right of action. And then he goes on to say at the outset of his memo that he doesn't even think it's a close question. He says, these provisions are patently unconstitutional. It's not even a close question. I'd encourage you to read the memo, or at the very least, the first 3 pages of it. Now, of course, he lost the argument. He didn't even win the argument within the Justice Department. The Justice Department, the Attorney General ultimately disagreed with him. And as was mentioned, the Supreme Court, shortly after this memo, not even a dozen years later, upheld the constitutionality of qui tam, at least in terms of the Article 3 question, the question of whether qui tam relators have standing to bring these lawsuits. I have to say, one of the greatest law classes I ever took was a class by Justice Scalia 20 years ago this year. It was a class about standing and the separation of powers, and we spent much of it on the Stevens case, the 2000 case upholding the qui tam statute. Scalia wrote the opinion on that case, and he found that qui tam relators have standing because they have a stake in the case, and the history of these lawsuits dates back, as we've mentioned, not just to the Civil War and not just to the founding, but much earlier than that. And for Scalia then, that was enough. I would suggest that that decision was wrong then and even wronger now. And I say that on the Article 3 question because you now see percolating up from the lower courts, especially with a concurring opinion by Judge Newsom of the 11th Circuit, a real question about whether the court got its standing analysis right in Lujan. didn't put this in the readings, but Professor Jonathan Adler of Case Western has a really interesting article. It's up on the homepage of the center that I run right now, the Center for the Study of the Administrative State here at the law school, really trying to think through what the rethink of standing might mean for qui tam lawsuits and other things. But for what it's worth, I actually think the Article 3 questions, the standing questions, are harder than the Article 2 questions. And that's what I'm going to focus on here. I think that qui tam, as OLC Chief Barr noted in 1989, it raises profound questions under Article 2 of the Constitution. And frankly, I think the trajectory of the Supreme Court, including on a lot of the issues that I study regarding day-to-day administration and administrative law, is trending towards Bill Barr's analysis in 1989. He raised the Appointments Clause question. A private attorney general, when he or she is authorized to move forward with the suit, wields enormous governmental power. That's why they're private attorneys general. That's why I want to say so much of what was offered in the really eloquent presentations by Shelley and Jonathan to start the conversation. A lot of what they describe as features of those statutory frameworks, I think, are constitutional bugs. And when you describe qui tam relators as basically serving as auxiliary manpower for understaffed justice departments or attorneys general offices, when we call them sort of casually private attorneys general, we really illustrate the problem here. These individuals exercise enormous law enforcement power. That's the point. They have minimal oversight. Even the oversight that was described here, I think, doesn't do nearly enough to cabin the actual discretion they wield. And the Supreme Court increasingly recognizes that powerful offices like this need to have leaders who are appointed by, or occupants appointed by the president, or at very least with the Senate's advice and consent, maybe by the head of the department, maybe by the Attorney General. But I think the qui tam relators and other private attorneys general increasingly raise Appointments Clause questions. I think the more salient question actually is whether they are being unconstitutionally delegated government power. Because if they are not really government officials, if they truly are private, well, that raises an entirely different category of constitutional questions. The Supreme Court recognized this nearly a century ago in a case called Carter versus Carter-Cole. It came up a few years ago in litigation surrounding Amtrak, and the question about whether Amtrak could exercise regulatory power if it's a private company. The Supreme Court ended up sort of sidestepping the issue by saying, actually, Amtrak is not private, it's public. As my former law colleague said, well, that's obvious. If you don't believe Amtrak is a government entity, try the food. But there was a real question in that case about whether Amtrak was a private company wielding government power. And you had Justice Thomas and others saying this is a very serious question. And I think Justice Thomas and others may return to that question. Right now in the D.C. Circuit, there's a constitutional challenge to FINRA, the private financial regulator. The D.C. Circuit is asking right now whether that entity unconstitutionally wields public power. And I think that either the D.C. Circuit's decision in that case, or if it goes to the Supreme Court's decision in that case, will have a real gravitational pull on the constitutional issues around private AGs. And oh, by the way, while the Supreme Court upheld qui tam in the Stevens case in 2000, Justice Thomas has raised new questions about it. Just this year, in his dissent in a case called U.S. ex rel Polanski versus Executive Health Resources, another qui tam case, Justice Thomas dissented and along the way said he has real constitutional questions about qui tam. And Brett Kavanaugh and Amy Coney Barrett, while they concurred with the court, they didn't dissent. They issued a separate opinion, one paragraph saying, we agree with Justice Thomas. There are real constitutional questions here around Article 2. In the end, I'll just say the reason why I so much like the name of the C3 I'm on the board of now, the Center for Constitutional Responsibility, is that I think it really illustrates the problem here. That we're outsourcing law enforcement power, often for good reasons, and I'll circle back to that, although I've already basically used up my time. They're wielding government power without real accountability through the proper way that we hold the execution of laws accountable through elections of our presidents, our governors, or our attorneys general. Just very briefly, I'll say at the end, I do think this is the rise of these private rights of enforcement, and our notes have a forthcoming law review article in the Penn Law Review that illustrates the rise of these things. I think it's part of a broader trend, a bad trend in law enforcement. We've referred to some of these things. Right now, a lot of prosecutors don't actually want to enforce the laws. Right now, a lot of prosecutors want to focus on higher profile political prosecutions, including cross-state prosecutions. We saw recently law enforcement officers in one state threatening to sue officials in other states. And what everyone thinks of the merits of the issues in any of those cases, the fact is a number of prosecutors are finding that they can get more attention, more political bang for their buck by walking away from day-to-day crime and focusing more on big-ticket items. And the third crisis, the one that's this one, is that legislators don't trust prosecutors to prosecute. They don't trust them for better and for worse. And so as Jonathan pointed out, a lot of the rise of issues like this, including in Texas, are an effort to simply outsource prosecutions to people that the legislator trust more than actual law enforcement officials. I'll say I think this is a huge problem of weaponizing legal uncertainty. At the Center for the Study of the Administrative State, we focus a lot on the problems of agencies trying to regulate, not by making and enforcing rules, so much as by increasing legal uncertainty and trying to leverage it, trying to deter conduct, basically through the interorum effect of unclear laws or enforcement schemes. And as Jonathan pointed out in one of his slides, I think it was titled How This Works, that's exactly what states are trying to do, weaponize legal uncertainty. I might agree with the underlying policy, but it's no way to run a country, much less a constitutional country with a separation of powers. So my bottom line is, I think we will soon see a judicial reconsideration of qui tam and many private rights of action. I think their constitutional flaws are more salient than ever, both in light of our better understanding and appreciation of constitutional history, but also in light of the current trend lines in the Supreme Court. And here I really think the trend is our friend. I'm not opposed to whistleblower statutes or giving awards to whistleblowers. It's when you go that extra step and actually outsource enforcement power in the courts to private hands that we have a constitutional problem. We live in an era of judicial recognition of the dangers of unaccountable administrative power and the need for steady administration of the laws. And I simply think that these alternative enforcement schemes are the antithesis of both.
Great, thank you. All right, so we've got about 15 minutes for questions, and I see microphones on either side of the aisle. So who wants to get us started?
What if there's corruption in all sectors of the levels of decision? Wouldn't you say that qui tam would be good in that circumstance?
I missed the second part of your question.
What if there's corruption at all levels of the places where decisions will be made? Wouldn't qui tam be good in that circumstance?
It would. Can I take that first? I was filibustering, but I'll answer first. Yeah, it will be good in many ways, and it will help to avoid the problem of corruption if it exists. That's certainly true. It's kind of like the arguments for the independent counsel in Morrison v. Olson, where advocates for that independent counsel said that these sorts of laws simply can't be committed to the Justice Department under its normal operations because there's a risk of presidential influence. It's a strong argument. But as Justice Scalia pointed out in his dissent, there's deeper problems in solving that problem by taking these things outside of the normal accountability measures of elections.
Don't you think it's an extraordinary circumstance anyway if there's corruption all over the place?
Well, we live in a fallen world, so I don't really know how far to take that. But I would say that you solve corruption in government by getting better government, not by outsourcing law enforcement power or other government power into private hands and hope that people outside of elections will do the right thing.
I sat by designation in a Supreme Court case, and it was a qui tam. So it made its way all the way to the Supreme Court of our state. The reason that I'm a trial judge and the reason that I sat by designation is that there was some interest by some of the justices there, and so it was paid for play. You may know, heard of Bill Richardson, who was governor of our state. There was a scheme for pay for play, and then there was a key time action to recover the monies that had been given into play. So that seemed to be the only device in view of the interests of the people in government to recover the funds that had been unjustly paid. I'm sorry, I don't mean to grandstand, but it just seemed to me that it was, and perhaps I am grandstanding, and I'm just seeing it seemed like a good device at that time in view of the circumstances.
Yeah, if I could
Thank
jump,
you,
if I could
panelists.
jump in, I think you made an excellent point. And above and beyond the corruption, you also have captured agencies, particularly in Washington, D.C., probably in the states as well. So the agencies will always the agencies are the source of the fraud referrals to the Department of Justice ordinarily. And so an agency that's captured is just not that likely, compared to a private whistleblower to make that referral. And in addition to the issue of the captured agency, you also have the resource problems that we spoke about earlier, but I think you make a good point. I think the key thing is really that the devil is in the details of these statutes. Not every private citizen provision is like every other private citizen suit provision. Like KETAM and the False Claims Act does have a lot of checks. I mean, the fact that the Department of Justice can settle that case, can dismiss that case over the objections of the relator, even if the case has gone forward after their declination is major. You don't have that in all these private suit provisions, and I think it's important to look at each one carefully. And I agree with Adam that I think the Supreme Court probably will take up this question, but at that point, I think it'll be very, obviously very well briefed, and they will be able to focus in on all these different checks in the False Claims Act, a KETAM statute.
And do you think we need more litigation and more of a history to appreciate its benefits and the detriments of the?
I think there's plenty of examples right now.
You do?
The one you
Okay.
mentioned is a great one, but there are many others too.
What about the separation of powers principle that you were talking about? And so I was wondering, do you think there's a real threat to government that the legislature would take over the executive, or the executive would take over the legislature, or the courts would take over the executive, or something like that?
Well, that's one of the risks, but frankly, legislatures do less and less, and so I'm less worried about them micromanaging executive power than I am worried about them to simply outsource it to others. One example I'd include, in addition to all the ones we just described, there was a case also, I guess, 20 years ago. It was, the Brady, we call it the commandeering case. It was the Brady Handgun Act case, where Congress created the new gun rules, many of which I'd agree with, and say, well, state law enforcement officials should enforce this, first and foremost, rather than federal law enforcement officials. And the Supreme Court, that case is famous for the court striking down the law. Sorry about that.
Oh my God.
I didn't actually mean to that time. That one was not too. But there was a challenge brought to the law, and the Supreme Court agreed with it. And the Supreme Court said the famous holding is Congress can't commandeer the states. But there was a secondary holding. They said Congress can't outsource law enforcement power out of the president's hands into other hands. That itself raises constitutional problems. And that's the line of thinking that I think is more worried. Not that Congress is going to take away the president's law enforcement power and keep it for itself, or at the state level, a governor or a state AG, but rather Congress is going to take it out of the executive branch's hands and just sort of spread it around like Johnny Appleseed.
Thank you.
This is predominantly Mr. Mitchell. I guess my concern is, my name is Gina, and admittedly I'm from Texas. My concern is, how do you reconcile the fundamental policy and economic policy differences between something like a KETAM auction, which goes to harm to the government and therefore harm to the public as a whole, and is seeking an economic benefit back to the government and the public as a whole, with the Texas Heartbeat law that goes after one private citizen for another private citizen with no economic benefit, and in my opinion would create more uncertainty in the legal and economic systems, right? Because you're also targeting behavior that theoretically the behavior itself was legal if it was done in another state, like, for example, New Mexico. So how do you reconcile that, especially because if one of the targets is this concern about judges not enforcing the policy and not enforcing the laws, et cetera, when it wouldn't have been even an issue because that behavior was legal where it was done?
Yeah, so the Heartbeat Act doesn't apply outside the state of Texas. So you can't
Okay.
sue, you cannot sue someone under the Heartbeat Act for an out-of-state abortion.
Okay,
I'm
so
sorry if that wasn't.
then I misread it, because my reading of it was that if the person had gotten the abortion in another state where it was legal, it was still prosecutable civilly in Texas.
No, it can only apply. So statutes are presumed not to apply extraterritorially unless there's a clear statement saying it applies extraterritorially, and there's no statement to that effect in the Heartbeat Act. So your other point about how this goes beyond traditional qui tam, I think you're right. I mean, and you should correct me if I'm wrong, but normally qui tam has been used, at least at the federal level, to remedy crimes or violations of law that inflict financial harm on the government. And then the
Yes.
qui tam relator is essentially acting as an agent of the government to claw back the money that was taken. This is definitely a variation on the traditional type of qui tam. So what my remarks were, and I want to be careful, I wasn't trying to defend the substantive policy in the Texas Heartbeat Act. That's obviously a very controversial question. My point was more limited, which is qui tam and private civil enforcement and private attorneys general can be used not only to counteract executive branch officials who just sit on their hands and won't enforce the law, it can also be used in some situations to counteract the judiciary. And that's all I was trying to say about the feature of that. Whether that's a good thing or a bad thing, that's people can debate that. But the benefits that can be drawn from private civil enforcement regimes is how they can essentially serve as part of checks and balances. And we often think about it as checking the executive, but the Heartbeat Act was actually designed intentionally to check what the Texas legislature perceived as misuse of judicial power and not just misuse of executive power.
Thank you.
Yeah, I think some of what my comments are have already been answered, but it seems to me there's a great distinction between the traditional qui tam provisions that Ms. Slade was talking about, where there seems to be government oversight so that you just don't have, plaintiffs going half-cocked because they have demented theories about government misuse, right? I mean, the government does have to kind of counterbalance what they're doing versus the Texas Heartbeat Bill, which avoids what was constitutional. I don't understand how, if the Texas legislature and the executive deem abortion to be illegal, they could avoid their then illegal acts by hiding and saying, oh, we're not going to enforce it. I think it creates vigilantism, which would go in other spheres. So, for example, as Governor Newsom said, we don't like, the Second Amendment, so we're going to create a law that allows citizens to go after anybody who carries guns. Then there's no law, and it seems that it kind of hurts your principle that the judiciary needs to be checked, because you have citizens of all ranges abused just going half-cocked to enforce what they believe is the right interpretation of the Constitution. So if you could remark on that, thank you.
Yeah, so there's a lot going on there. Let's talk about Newsom's situation first. There are two big differences between what Newsom tried to do in California and what Texas did with the Heartbeat Act. Number one, Newsom did not target any conduct that the Supreme Court had ever held to be constitutionally protected under the Second Amendment. He only went after assault weapons and ghost guns. There is no ruling from the Supreme Court that says that that is protected weaponry under the Second Amendment. Notice, he didn't go after handguns. Even in California, they didn't have the votes to do something like that. Second, Newsom did not take away the authority of public officials in California to enforce the ban on assault weapons or ghost guns. So it still remains possible, even after what he did with private civil enforcement, to sue state officials in California and argue that these restrictions violate the Second Amendment. So the media tried to paint Gavin Newsom as turning the tables on the conservatives and showing that two people can play this game. What Newsom did doesn't hold a candle to what Texas did with the Heartbeat Act, because it's still possible to come into federal court in California and raise a pre-enforcement challenge. The issue of vigilantism. The Texas Heartbeat Act was designed to reduce compliance. It was never intended to unleash a wave of vigilante lawsuits, because the whole point of the law is that people would comply instead of subjecting themselves to those risks. The idea was laws exist to be obeyed, and this was a mechanism to induce compliance. The last thing in the world the authors of the Texas Heartbeat Act wanted was for people to start filing civil enforcement lawsuits before Roe was overturned, because that would have given the courts a chance to rule on the constitutionality of the Heartbeat Act, and they would have had to declare it unconstitutional because Roe hadn't been overruled yet. So the idea was actually never to have these lawsuits filed in the first place. And that's essentially what happened. There was a guy who wrote an op-ed in the Washington Post, I don't know if you remember this, about 2 years ago. He said, "I violated the Texas Heartbeat Act. Please come sue me." And he actually did that on purpose because he wanted to provoke a court challenge because the people who opposed the law weren't able to find any defendant to sue in federal court. And people were coming to me, they were sending me emails saying, "I want to sue this guy. I want to be a bounty hunter." I said, "No, do not sue him. Please, wait." Right? Roe hasn't been overruled yet. He's trying to bait you into suing him to try to get this litigated into court. So it was a very odd situation where the people who opposed the law were actually trying to provoke a lawsuit, and this guy did by violating it once, or at least claiming that he violated it once. And then people who were trying to keep the law in effect were trying to tell other people, don't sue this guy yet, wait for the Supreme Court to rule in Dobbs. So it was an unusual situation because it was going after conduct that the Supreme Court had held to be constitutionally protected, but certiorari had already been granted in Dobbs, so people were kind of waiting to see what the Supreme Court would do. Again, I'm not sure this tactic works in a situation where the Supreme Court clearly backs the right at issue. Because in those situations, you can violate the law, and you don't have to fear the enforcement lawsuit. It's possible somebody might sue you purely out of spite, but there's no reason you should worry about having to pay out damages in the end if you know the federal judiciary has your back. The problem with the Heartbeat Act was they couldn't count on the Supreme Court because of the grant of certiorari in Dobbs.
You mentioned that Chief Justice Roberts was a critic of that, and I think you framed it in terms of judicial supremacy.
Yeah.
He was definitely a critic, but I don't read the reasoning the same way. On the current Supreme Court, Chief Justice Roberts is second to none in his criticism of administrative power, especially unchecked administrative power and unaccountable administrative power. And also, he's been a vocal critic of the kind of regulatory uncertainty that defines modern administration. He has been among the most vocal critics of that, tied with, say, Justice Thomas and Justice Gorsuch. And that's what I see animating his criticism of the enforcement mechanism in the Heartbeat Act.
But this was
And this, I'll just say,
yeah.
speaking as a pro-lifer who agreed with Dobbs and who understood why the law in Texas needed to be written, gerrymandered around judicial power, federal judicial power in that case, I can agree with the motivations, but it's no way to run a constitutional country.
But this was a state law, though. I mean, Chief Justice Roberts and the U.S. Supreme Court, they have no say on how a state allocates power among the different entities.
Yeah, but there were-
Isn't that right?
Well, yes, although the Constitution, first of all, has a Republican guarantee clause,
That's
the
true.
U.S. Constitution.
It was a Republican-controlled state legislature that passed it.
Well, it was, yeah. Yeah, a lot of Republicans aren't as Republican as they used to be.
All right, it's just past 10:45, so I think that'll close us out. But if anybody has follow-up questions for this panel, I'm sure they'll stay for a minute.